Welcome to this explainer. We've got a really special one today, tailor-made for lawyers, law students, and bar examinees. We are going to rigorously dissect the Supreme Court case of People versus Palabrica III. So, if you're looking to master the intricacies of the Anti-Graft and Corrupt Practices Act, or if you just want to see a totally masterful application of statutory construction in action, you are in exactly the right place.
Now, definitely pay close attention to the author of this quote. This decision was actually penned by Justice Samuel Garland, who, happens to be the current bar chair. Now, he didn't decide this alone. He was acting as the ponente for the Second Division. But his framing of these legal principles makes this absolutely essential high-yield reading for the bar. When the current bar chair emphasizes that the end does not justify the means in the context of the presumption of innocence, we all need to pay very, very close attention.
Okay. Let's run through our roadmap real quick. We'll hit the facts of Mayor Palabrica's case, break down the elements of Section 3H, look at the market stall lease, ask if permits are actually considered transactions, apply the doctrine of noscitur sociis, and then wrap up with the Supreme Court's final verdict.
All right, Section 1, the case of Mayor Palabrica, a factual hook. Every great case starts with a compelling story, right? So Rufino Pablo Palabrica III was the mayor of Dingle, Ilolo. And he also happened to be a licensed physician. Way back in 1996, which was long before he was ever mayor, his medical clinic and his Farmacia Francisca started leasing stalls in the local public market. Fast forward to 2005, and he's rendering free medical services there for his constituents. But the legal trouble really kicked off in 2014. Why? Well, in his capacity as mayor, he signed a market stall lease renewal for his own pharmacy. Basically, he signed as the lessor for the municipality and as the lessee for himself. And on top of that, he issued a business permit to that same pharmacy. Because of this, he got slapped with 2 counts of violating Section 3H of the Anti-Graft and Corrupt Practices Act.
Moving right along to Section 2, elements of Section 3H, deconstructing RA 3019.
So, to really understand this, let's summarize the specific elements the prosecution absolutely must prove beyond a reasonable doubt to get a conviction here. Step 1, the accused is a public officer. Step 2, the accused has a direct or indirect financial or pecuniary interest in any business, contract, or transaction. And Step 3, the accused intervenes or takes part in an official capacity in connection with that interest. It's a strict test. If the prosecution misses even one of these elements, the whole case falls apart.
Which brings us to Section 3, the market stall lease, analyzing the first charge.
Let's go ahead and apply those elements to the first charge, signing the lease. Was he a public officer? Obviously, yes. Did he have a pecuniary interest in his own pharmacy's lease? For sure. But what about that third element? Did he actually intervene? Well, the Supreme Court stepped in here and clarified that a mere signature just doesn't cut it. The law strictly requires actual intervention in the transaction. The whole point of the statute is to prevent the dominant use of influence, authority, and power.
And in this case, the court found that third element of actual intervention totally missing. Why? First off, this wasn't some new, shady sweetheart deal. It was a pre-existing lease he'd held since 1997. Second, signing it wasn't a rogue act of self-dealing. He was explicitly authorized to sign lease contracts for the municipality by a prior Sandiganbayan resolution. Plus, Section 444 of the Local Government Code literally mandates the mayor to sign contracts when authorized by the council. And honestly, the prosecution brought zero evidence that he got any special treatment or strong-armed the approval. He was just signing as the authorized representative. So, no actual intervention means absolutely no conviction on charge number 1.
All right, Section 4, are permits considered transactions, the core issue?
This is the real climax of this explainer. The second charge was all about issuing the business permit. So we have a million-dollar question. Does issuing a business permit constitute a transaction under Section 3H? Remember, that second element requires a pecuniary interest in a business, contract, or transaction. Now, the Sandiganbayan initially said yes. They convicted him using a super liberal interpretation of the word transaction, kind of just tossing permits under that umbrella. But the Supreme Court pushed back hard on this to see if that legal element was actually met.
Let's look at exactly how they did it in Section 5. Applying noscitur sociis, high-yield statutory construction. To definitively answer that question about permits, we get to dive into some seriously high-yield bar material, statutory construction. We're talking about the doctrine of noscitur sociis. It literally translates to, it is known by its associates. Basically, if a word in a statute is a bit obscure or ambiguous, you figure out its meaning by looking at the words right next to it. In Section 3H, the word transaction isn't just hanging out on its own. It comes right after business and contract. So we've got to read transaction through the lens of what businesses and contracts actually entail.
And think about the stark contrast we end up with here. If we apply noscitur sociis, a transaction, because it's grouped with businesses and contracts, inherently requires some kind of monetary consideration or exchange. A contract is a binding agreement for consideration, right? But a business permit? That's not a contract between the sovereign and the permittee. It's just an exercise of delegated police power. Sure, it authorizes a commercial activity, but there is absolutely no monetary exchange or mutual contractual obligation happening between the government and the applicant. It's simply an authorization subject to strict legal requirements, meaning a permit is fundamentally not a transaction under this specific law.
Let's bring it all together in Section 6, the Supreme Court's verdict, strict construction of penal laws.
Here is our ultimate doctrinal takeaway, and it's a foundational principle of criminal law. Since a business permit is not explicitly a transaction, we simply cannot stretch the definition of the word just to make it fit. The Supreme Court emphasized that we have to apply a restrictive interpretation of penal laws here. We must construe the law strictly against the state and liberally in favor of the accused. It's absolutely crucial for safeguarding the rights of the accused against improperly expanded definitions of crimes. If an act isn't clearly and unequivocally made criminal by the statute, the court simply cannot punish it.
And that brings us to the final conclusion. The Supreme Court ultimately acquitted the mayor on both counts. They found no actual intervention in the signing of the lease, and they definitively ruled that a business permit is not a transaction under Section 3H. It really leaves us considering this critical balance, doesn't it? How do we aggressively fight corruption while still upholding the constitutionally enshrined presumption of innocence? Like Justice Garland wrote, the end doesn't justify the means. It leaves a pretty provocative question for all of us. Are our current penal laws drafted precisely enough to catch actual corrupt practices without ensnaring innocent, routine administrative acts?
I really hope this breakdown gave you a crystal clear understanding of the elements of Section 3H and that brilliant application of statutory construction by the Supreme Court. If you found this case digest valuable for your studies, your bar prep, or your practice, please make sure to hit that like button, comment your thoughts or any questions you have down below, and subscribe to the channel for more highly focused legal explainers. Keep studying hard, and we'll catch you in the next one.